have two special guests. Now, I'm going to give you a quick rundown here before I introduce my special guests. But Jeff Havard is an individual who has been convicted of capital murder in Mississippi. Now, to convict of capital murder, if it's not premeditated, you have to have an underlying felony. In the case of Jeff Havard, the underlying felony that will enable prosecutors to convict him of capital murder was sexual battery or sexual assault. Joining us today, we have a very distinguished guest, ex-Mississippi Supreme Court Justice. That's Justice Diaz, Justice Oliver Diaz. Are you with us?
Yes, I am.
Hi, Justice Diaz. How you doing?
Doing fine, thanks. Good to talk to you.
Good to talk to you, too. And shortly, a very accomplished defense attorney, Jennifer Fitzgerald, will be joining us, and she is also familiar with the case of Jeffrey Havard. Now, if we can just start with this, I'm going to give a quick rundown, Justice Diaz. I'm going to give a quick rundown, and well, it looks like Jennifer, Attorney Fitzgerald needs help calling in, so I'm going to help her call in real quick. Basically, in a nutshell, I'm going to explain the entire. Brevity is not my specialty. That's one thing you'll learn. But basically, Jeff Havard was a 23-year-old man. Now this is by all accounts, he was involved in an incident. Now there is the police side of the incident, and then there is the accused side. Excuse me, the police side of the events that happened that night, and then there are the accused sides of the events that happened that night, which we're going to discuss today. Ended up a 6-month-old baby, Chloe, by the name of Chloe Britt, perished that evening. Now, therein lies a lot of controversy, but we'll get into that. But she perished that evening. Later that Thursday night, on February 21st, 2002, Jeff was arrested, or shall we say detained for questioning, but he was under arrest for capital murder. And I believe we have Jennifer joining us right now. Jennifer, are you with us?
I am. I'm right here.
Hi, Jennifer. Welcome. Justice Diaz and I are here.
Thank you for having me.
And thank you for calling in. And I appreciate your time, too. And let's cut to the chase here. And we'll start with you, defense attorney Jennifer Fitzgerald. You and Justice Diaz are both obviously extremely accomplished. And Jennifer, why don't you give me a quick rundown of just your history and your background with the law?
I've been a practicing criminal defense attorney for about 14 or 15 years. I spent the first 11 years as a attorney in the public defender's office. I practice in Rhode Island, which obviously means that I'm not involved as an attorney in Jeffrey's case at all, although I have studied Jeff's case for the past couple of years and have really, I guess, become involved as far as moral support for him and advocating to try and get others to take a look at his case and see what kind of a situation we're dealing with and how it went wrong.
Okay, yeah. So you have an interest in the case, and obviously you're well versed in the law, 14 years. And if I'm not mistaken, you graduated from Tulane University?
I actually graduated from the University of San Diego, and I did my last year of law school at Tulane.
At Tulane, which is in the which is not too far from where this incident took place in Natchez, Mississippi.
Correct.
Justice Diaz, would you be kind as to, perhaps give us a quick 1, 2, 3 on your background?
Well, sure. I've of course been an attorney for a number of years. I served in the Mississippi House of Representatives for several years before moving on to the appellate courts in the state. I served on the Court of Appeals in Mississippi for 5 years, I think it was, from 1995 through 2000. I was on the Mississippi Supreme Court from the year 2000 through 2009. I'm now back in private practice in Jackson, Mississippi, and trying to make enough money to put kids through college.
And a noble cause that it is. Well, actually, by the way, one of the people we're going to talk about here, one of the witnesses that, I guess you could say the star witness, if I may, Dr. Stephen Hain. I don't know if you knew this, defense counsel Fitzgerald, but he actually went to college in Rhode Island at Brown University.
Yes, he went to medical school in Brown, from what I hear. At Brown, from what I hear.
Yeah, that's confirmed. And I'd also like to say before we start this that we're also, we represent Cornell University Advocates for Human Rights and the Cornell Death Penalty Project, my alma mater. And let's dive right in here to this here. Now, as I explained briefly, and again, brevity is not my specialty, but as I explained briefly, back in 2002, Jeffrey Havard was charged with capital murder. Now, the actors involved here, you're going to hear Prosecutor Ronnie Harper. You're going to hear about Jeff's defense counsel. And I've got a bevy of questions that I would like to address both of you, really. Let me start off with you, okay, Jennifer?
Sure.
Could you walk us through what you can walk us through about what you know with regards to the trial phase in the Jeffrey Havard case?
Sure. I don't know if you gave any background before I had called in, but it would be redundant for me to sort of talk about how the case came about. But is that what you'd like me to do?
Basically, a quick summation, because I know we could
Sure.
get into detail and have a 24-hour conversation on this.
Absolutely. There's a lot going on with this case. Essentially, Jeffrey had been dating a woman by the name of Rebecca for a couple of months, and they decided to have Rebecca and her 6-month-old baby, Chloe, move in with Jeff. One evening, Rebecca was going to go to the grocery store to pick up some groceries for dinner, and the plan had been that while she's doing that, Jeff will give the child her bath and put her to bed, and when Rebecca returned, they would have dinner and watch some movies that Rebecca was going to rent at Blockbuster. So that night, when Jeff, right after Rebecca had left, Jeff had noticed the child started crying. So he went to change her diaper, but didn't notice anything wrong. She didn't need a diaper change. So he went to give her a bath, and he ended up giving her bath. And then, unfortunately, as he was lifting her out of the tub, she was wriggling around as kids do, and she slipped from Jeff's hands. And when she did that, she hit her head on the top of the porcelain toilet, and I believe her leg hit the side of the bowl, and in a pure accident, and which had obviously a tragic result. Now, when this immediately happened, the child didn't really react. In other words, she didn't make a sound. So a couple of seconds went by, and then she began to cry, and Jeff at that point just sort of comforted her and felt that everything was okay. After a few minutes of consoling her, and he took her in and changed her diaper and dressed her for bed and laid her down. And everything at that point in time seemed to be fine, which is pretty much consistent with a lot of cases of either children or adults who have suffered some type of head trauma, that at first they seem to be perfectly okay. So he put her to bed, and Rebecca came home from the grocery store and checked on her, and she seemed to be fine. And then Rebecca realized that she had forgotten to stop at the video store, so she went out again. She went out again for about correct. She went out again for about 15 minutes and came back. And when she came back, she noticed that the child wasn't breathing and that the child looked blue. So she immediately picked the child up and brought her into the living room and started to perform CPR on her. Rebecca didn't know, wasn't trained in CPR, but she had a mother who was a nurse who she had indicated had taught her how to do it. The child was not responsive, so the three of them jumped in the car and drove over to the hospital as quickly as possible. And when they got to the hospital, they handed the child off to the medical staff. And unfortunately, at that point in time, being frightened and certainly concerned, Jeff did not tell the medical staff that he had dropped the child. And Jeff recognizes that that was obviously not the right thing to do. He regrets that, very much to this day. But it's important to know, I think, that the medical staff automatically treated her as if she had a head injury, and that had Jeff told the medical staff that he had, dropped her, lifting her out of the tub, it wouldn't have changed anything that they did medically or anything that they had done to try and save the child's life. They wouldn't have done anything differently. So it's not a matter of him staying silent while they were trying to figure out what was wrong with her and couldn't treat her for that reason. Very quickly, the doctors realized how serious it was, and almost, I would say 20 minutes after Jeff even arrived at the emergency room, police were called, and he was immediately taken away by police car to the police department. What had happened is while they were treating her for a head injury, one of the nurses went to give the child take her rectal temperature. And when she did that, the nurse noticed that the child's anus had been dilated to about the size of a quarter. Upon seeing that, the nurse immediately jumped to the conclusion that the child must have been sexually assaulted. There was absolutely no allegation of sexual assault prior to that. Nobody suspected it prior to that. It was simply on the basis of seeing the condition of the child's anus. The doctors then took a look at it, and everybody sort of, immediately came to that conclusion without doing any further real, medical investigation or differential diagnosis. They all sort of agreed that the child had been assaulted, and one of the doctors taking a look at the child's head injury and so forth had determined that she had been shaken to death. And I think the child was, from start to finish, was in the hospital a little over an hour, and they had determined that Jeff was the one that had done it, and Jeff had sexually assaulted the child, and then once he was done doing that, he violently shook her to death. And that's how the charges were filed, exactly. And then I know the answer to this, but I'm going to tell our viewers anyways, Jennifer, and manslaughter, second degree, negligent homicide, things like that, that's one thing. But when you have an underlying felony such as sexual battery, as they ascertained, that's what makes it a capital murder case. Correct. And the reason being that whoops, go ahead.
I'm sorry, go ahead. The reason being?
The reason being that when you have a shaken baby case, in most states, when people, and in Mississippi as well, when somebody's charged with shaking a child, it's usually out of some type of frustration for something that the child's doing, and the person, it's really more of a second degree, at the very most, second degree murder type of charge, because it's not a premeditated intentional killing. In this case, it took it out of the second degree murder category because it was alleged to have happened while he was committing this other felony of sexual battery. So that's why when you see people charged with shaken baby in the death of a child, you're not normally finding them on death row. In this case, though, it's a whole different ballgame.
Let me ask you this, Justice Diaz. How do I phrase this? Let's suppose that they didn't ascertain any and all whatsoever. They had no indication of any sexual battery whatsoever, and so therefore there was no underlying felony. Correct me if I'm wrong, but the accused in this case, Jeffrey Havard, he would not have been facing capital murder charges. What type of charges, if any, might he have faced had they not decided that there was a sexual battery that took place?
Yeah, well, that's a good question, and you're absolutely correct. Without an underlying felony, without an underlying another felony crime, the charges would have been quite different. I mean, it could have been anything from nothing. It could have been ruled an accidental homicide. It could have been some sort of manslaughter, something along those lines. But it would have certainly not merited a death penalty conviction. You know, even the most heinous type murders in most states, in Mississippi is one of those. Simply killing another person is not enough to land somebody on death row, even when it's done, particularly brutal fashion. There has to be some other underlying felony, and it's usually something like a rape or an armed robbery or something of that nature. So without the underlying felony of sexual abuse in this case, Mr. Havard would not be on death row.
So it's fair to say that Mr. Havard's execution and or potentially exoneration really lies solely upon this accusation of sexual battery.
Yes,
and refuting
correct.
that. Justice Diaz, I have another question for you, and this may be a complicated question, but I figure, I have two people on the phone here who have forgotten. Like I told you yesterday, you've forgotten more in your lifetime than I'll ever know in my lifetime ever. So I'm talking to two people who are far more intelligent than I. But from my research, I understand that originally, Mr. Havard, there were two underlying felonies, in fact, one being sexual battery, the other being felonious assault on a child. And for some reason, and I have not been able to figure it out, which is why I'm asking you, Justice Diaz, for some reason the state of Mississippi dropped the charge of felonious assault, I believe, on the eve of the trial?
Jennifer, I think, is more familiar with the facts of the underlying case, so she may be able to speak to that better than I can.
Sure.
Do you know anything about?
No problem. Yeah. What the state had done originally when Jeff was indicted is they charged him with two underlying felonies, sort of in the alternative. In other words, the jury could find that the death had occurred during the course of a felony child abuse. Just that did not involve sexual assault whatsoever, the abusive conduct towards a child, or that it had occurred during a sexual battery, or both. So there was two different theories that the state was going under. On December 16th, which is actually the day before testimony began, it was the day that they started selecting the jury. On that day, the prosecutor came in inexplicably and moved the court to dismiss the one felony, which would have been the child abuse, and he was going to proceed solely under the sexual abuse theory. That is really the $64,000 question as to why they did that. The defense at that point, of course, did not object. As I don't think I would have objected. I wouldn't. To this day, I can't figure out what their logic was, because what they essentially did is they eliminated one avenue for the jury to have been able to find for capital murder. something had to have been brought to the prosecutor's attention just prior to the time of trial for them to do that. I'm not sure to this day what it was, except.
How about this? How about this, Jennifer? Let me float this out there for you. And this is again, I'm just a layperson talking, and not a very intelligent one at that. But let me just throw.
That's not true.
Let me just float this theory out there. Perhaps originally the state, and this is just conjecture on my behalf, perhaps the state, originally, as they would say, through the book, and took both underlying felony charges just to kind of, if you will, double their chances of gaining a conviction, of giving them the option of going one route or the other. And when they finally decided on a route, that being sexual battery, they didn't want to confuse and confound the jury. So perhaps they wanted the jury to focus solely on this sexual battery.
That's obviously a good guess, but that's all that we'd be doing at this point. Would just be pure conjecture. Would just be guessing as to why they did that. I know that there was later on down the line through the trial, there was quite a bit of contention between the medical expert that the prosecutor had called to testify at trial, which was the medical examiner, Dr. Hain, and the testimony of the doctors and nurses that treated the child at the hospital. There was a discrepancy over whether or not there was actually any evidence of sexual abuse. Obviously, we've just talked about how the doctors and nurses all saw the condition of the child's anus and immediately had felt that there was sexual abuse. Sexual abuse wasn't even mentioned in the autopsy report. There wasn't one word about sexual abuse. And Dr. Hain, who had performed the autopsy, he had been specifically told prior to the autopsy what the suspicions of the doctors and nurses were, and so he knew to check for that. And the bottom line is that he didn't even mention it in his autopsy report. There was also some confusion. Yeah, go ahead.
And we're going to get to that point, Jennifer.
Okay.
And we're going to eventually get to the point that Dr. Hain was really the only qualified expert to opine, to be tendered by the judge to be qualified as an expert witness. And that's another point of contention in this trial, which we're going to eventually touch on.
Okay.
Justice Diaz, being in Mississippi, being in that area back in 2002. Can you give me an idea? I mean, they have, the Natchez Democrat, the Clarion Ledger. Can you give me a general idea of how the general atmosphere was around there after the allegations came out that this young man sexually violated a 6-month-old child and committed capital murder in the process? Was there just a public outroar at that time?
Well, I don't know. The crime occurred, if there was a crime, it occurred in Natchez, Mississippi. I lived at the time in Biloxi, Mississippi, and worked in Jackson. There was not a great deal of media attention. This was not a case that this was an issue in. I mean, the attorneys didn't make an issue of pretrial publicity or anything of that nature, as far as I'm aware. But the pretrial publicity was not a major problem with this case, as far as I'm aware.
I think that one thing is that anytime you have a child that's alleged to have been murdered by somebody, there's the public obviously
emotion.
Correct, and so that's really what you had. But you're going to have that in any kind of situation like this, where
I'm sure
they want somebody to pay for it.
It's a much bigger story locally, I think, than it is statewide, and I'm sure there was intense focus on this in the local community. Yeah, as Jen says, anytime a baby is killed, the community is usually outraged. That's not something that's unusual at all.
So that's actually a good segue to my next question, and this is directed at Jennifer. Jennifer, as a defense attorney, okay, let's just say this was very locally, a very emotional case locally. Now, as a defense attorney in a trial, you're going through your voir dire stage where you're questioning the jurors and this and that. But as a defense attorney, okay, let's put you're representing, Mr. Havard. What are the pros and cons, and what would you have done in regards to perhaps a change of venue in this situation?
Jeff's lawyers opted, and Jeff obviously opted not to file a change of venue motion. It is something that I can tell from the transcript of the pretrial hearings. It was something that was considered, but they opted not to do that. I don't know what their particular feeling was or what their sort of legal reasoning was behind that, but I can tell you that if it was me, it's really hard to, hindsight's always 20/20, but I think that the failure to file a change of venue motion wasn't really a major problem in this case, because as we were talking about just now, anytime you've got a child that is alleged to be the victim of a homicide, and a violent and horrific one, like they were alleging in this case. Right.
You can go to the North Pole and
right, exactly.
Anything short of Mongolia.
The major problem in this case really came down to his inadequate legal representation, and I don't make that type of a claim lightly, because you never know. I mean, God, but for the grace of God, there go I, that I'm put in a situation where I have to make certain legal judgment calls and so forth. But in this particular case, there are many things that his trial counsel did that there's no basis in reality for them to have done. There's no logical or explainable reason why they could not go out and at least interview some witnesses, why they couldn't try and educate themselves about the medical science and so forth.
Let's talk about one of them right now, Jennifer, because I think I know some of the things that you want to get into, and I'm going to direct this at Justice Diaz. Justice Diaz, now there were, if you will, non-expert witnesses that were testimony was elicited out of these non-expert witnesses by Prosecutor Harper. Now, to my understanding, there was really I'm sure the reason Prosecutor Harper didn't tender these witnesses, speaking of the ER staff, in particular the doctors and nurses, was because they were not qualified as experts, and the judge would not have accepted them as experts. Is it ethical? The only one who was an expert in this regard would have been Dr. Hain. Is it ethical, or is it even legal for a judge to allow the prosecution to basically elicit expert testimony out of non-expert, if you will, lay witnesses?
Well,
does that make sense?
Your question touches, yes, it does. It touches on several issues, though. I mean, you asked about the ethics of doing that. I think that in a trial, you can ask questions in a trial. It's up to the opposing attorney to make objections to those questions. That highlights one of the major problems with the Havard case is the defense lawyers representing him at the time of trial. One of the issues on appeal is the ineffective assistance of his trial counsel. When questions like this were elicited from witnesses on the stand, they did not object to these witnesses, which a good defense attorney would have done. Most any attorney right out of law school would have known to object, would have known that you have to lay a proper predicate before someone is an expert in a field. The ineffectiveness of Jeffrey's trial counsel is also highlighted by the fact that they did not present expert witnesses of their own in Jeffrey's behalf. Now, a little bit of in their defense is that they did request experts from with the trial court. They asked the judge to provide them with funds to hire an expert so that they could represent Jeffrey. The court denied those funds, so they were not able to hire experts in the defense, and they compounded the problem when they did not object to the questions that the prosecutor was asking of witnesses who were probably not qualified to be experts in the case. So I'm not sure that it's an ethical problem, but it certainly is a problem with the defense that was provided to Jeffrey.
And I would even, you would agree too? Yeah. I would even take that a step further and, okay. Now, not only were they not allowed to, which I guess is a judge's discretion. A judge does have control of his or her courtroom. I'm not sure.
Can I say something about that?
Absolutely.
I just want to throw something in there. This is just because anybody that's listening to this might not really have a thorough understanding about how expert witnesses are allowed to testify as experts. And the bottom line is that case law and the Mississippi Supreme Court has stated that the judge is basically the gatekeeper of the courtroom, and that the whole idea behind expert testimony is not to allow people that the jury will perceive to have superior knowledge, like a doctor or a nurse and somebody that's very well educated, that they won't perceive them to have more knowledge than they actually do, or to be more qualified to testify about a certain subject than they actually are, because then that person's testimony is given undue credit. So what happens when either side wants to have an expert testify is they take the jury out of the room and they bring the expert in, and the expert testifies about how it is that they're qualified. Exactly, and that's how they're tendered as an expert. Both sides are allowed to ask questions, and then the judge makes a decision based on all of the qualifications, where they went to school, how many years they've been practicing, what specific reports they've authored and what studies they've done, and how they would specifically know about child sexual abuse and its diagnosis. And then the judge makes a determination as to whether or not the person is sufficiently qualified and whether it's relevant to the case. And if they do, then that person is considered to be an expert. They bring the jury back in, and then they allow the person to testify about what their opinions are. And in this case, the prosecutor simply did not tender or proffer the medical staff as experts. So none of the medical staff witnesses testified about really their qualifications. The treating physician, I think, said that she's an emergency room physician and she was on duty at the hospital that night. And that was the totality of what her experience was that was told to the jury. And so she should have been able to say, look, I saw a dilated anus, period. That's it. I saw this bruise, that bruise, we tried to resuscitate her, that kind of thing. What she could not say is that it was the dilated anus was caused by penetration. Only an expert can say that.
And basically, I'll put that into the simplest terms for our viewers who don't have JDs. Basically, what that means is a nurse and or an ER doctor, testimony can be elicited to them about what they saw, what they experienced. But as far as a connection to sexual abuse, they're not qualified to make that judgment. Only Dr. Hain was in this case.
Correct. That's absolutely correct. And he was properly, tendered and questioned beforehand and showed his expertise.
Now, this is actually leads me to my next question, and whoever wants to take this one can take it. Justice Diaz had intimated earlier that defense counsel did request, their own medical examiner, and that was obviously when they were denied. That was a key moment in this trial. If I'm not mistaken, from what I've read, I believe the judge instructed defense counsel Ramos and Clark to, no, you can't have your own defense counsel, but you can go ask Dr. Hain about it. And their mistake was they didn't ask Dr. Hain about it. Had they asked Dr. Hain about it, maybe things would have been different today. Am I correct in that?
Yeah, exactly.
Go ahead.
Yeah,
Go ahead,
it goes back to the point I was making earlier about ineffective assistance of counsel. I mean, they could have done lots of other things. A preliminary investigation of this case. They could have called other witnesses in defense for Jeffrey. They could have asked Dr. Hain questions, and they could have had an independent expert as well. I mean, all of these things could have been done, and they weren't done in this case. And I think if you had basically any one of them done, I think the chances are of a different outcome from this jury would have been significant chance.
I think that it's important for people to know that we have no way of knowing what Dr. Hain would have said to defense counsel had they gone out and talked to him. But you have to assume that Dr. Hain would have been, open and forthright with defense counsel as he was supposedly not aligned with either side, the defense or the prosecution. What we were able to learn long after the trial and long after Jeffrey had already been convicted in 2010 through a deposition that was done by the defense of Dr. Hain, where the prosecution was present as well. Dr. Hain was asked whether or not today he could come to a conclusion that the child had been sexually assaulted based upon the autopsy that he performed on the child. And Dr. Hain has unequivocally stated that he cannot now, nor could he then, back in 2002, at the time of trial, he couldn't then and he can't now say that the child had been sexually assaulted. What he said at trial was the prosecutor had asked him, what does the condition of the child's anus, what is that indicative of to you, Dr. Hain? Dr. Hain responded, it is, quote, consistent with penetration by an object. The problem with that is that all you're saying to the jury when you say that something is consistent with it, it means that he couldn't rule it out. And the reason he couldn't rule it out is because in the majority of cases of sexual abuse, there's no evidence of injury whatsoever. There's simply nothing. The child appears to be totally normal. So, in other words, it would have been the same testimony if he had taken the witness stand and done an autopsy and had found not a single scratch, bruise, or anything on the child, no dilation. It would have been consistent with sexual assault. Problem is that the defense didn't know this because they didn't talk to him, and the prosecutor did not elicit or ask enough questions of him for him to be able to explain that. And the prosecutor simply moved on to another topic the second he testified that it was consistent with sexual abuse. But that was not, Dr. Hain has never felt that this child was sexually abused. And that's the problem. The jury went into the deliberation room thinking he did. Mm-hmm.
Correct me if I'm wrong, defense counsel, or if you'd like to jump in here, Justice Diaz. Basically, what Jennifer is saying is that in the 2010 deposition, Dr. Hain stated this in very unequivocal terms. However, during trial, during the key time, that is the trial, in 2002, he was actually very equivocal and very vague, if you will. So why the change between 2002 and 2010? Why was he so equivocal in 2002 and unequivocal in 2010? Are you following me?
Yeah, and there's no way for us to know why he did one thing then. But again, it goes back to the attorneys at trial of not having been prepared to ask the proper questions and not asking the right questions when they had an opportunity. So that's why this case is so tragic. Had you had a great defense attorney from the very beginning, all of these issues would have been tested at trial. That's what a trial is for. And when you have an attorney who falls down on the job, an attorney who's not doing what they're supposed to be doing, then you leave these issues on appeal. We could have had answers to all of these questions had the defense attorneys been properly prepared, had they done their jobs at trial. And that's why you have a case like this that cries out for some sort of reversal at this point in time when you don't have a proper predicate laid, a proper trial from the very beginning. All you're doing is correcting mistakes from then on out.
Exactly, and I think it's important to, let me just point out that the trial lasted from start to finish 2.5 days. That's including jury selection. So you really had about a day and a half worth of testimony. And this is a case that it has highly technical medical evidence that people are testifying to. And as Justice Diaz just pointed out, the whole point of a trial is to get to the truth, is to have both sides put up their arguments, to have both sides ask questions, and to get to the truth. If we have a trial where the jury goes back to the jury room deliberating, thinking that Dr. Hain testified to them that the child was sexually assaulted, then we're necessarily not going to have a truthful verdict. We're necessarily not going to get to the truth. And that is what is so tragic, is that the jury simply, I think it's pretty clear, was provided a very misleading impression as to what Dr. Hain actually thought the evidence was, as to what his actual opinion was.
Just Diaz,
just to give you some baseline of what Jen was just talking about, a 2.5-day murder trial, the death penalty case. I was just in trial last month. We had a day and a half on an insurance case. This is just a civil case, a contract case.
Wow.
A day and a half to select a jury in that case, and we presented 3 witnesses in my case, and the trial lasted 2 weeks. When you have a death penalty case that lasts 2.5 days, including jury selection, I mean, you get some sort of idea of the amount of detail that was paid in this case.
Right. I mean, they had 14 witnesses testify one day. I don't think I've ever in my entire career had a case, in a criminal case, where I got direct and cross-examination, got through 14 witnesses in one day. Totally unheard of.
And this leads back to Justice Diaz's statement earlier, ineffective assistance of counsel. From what I understand, Mr. Sermos and Mr. Clark had only called one witness, and I believe it was a relatively irrelevant, if you will, witness that really didn't really help his client out at all. Now, I mean, from my understanding, Jeff actually babysat for his boss's daughters, ages 2 and 4, prior to ever meeting Rebecca Britt. And I mean, I can find nothing. I can find no information where he's ever exhibited any abnormal behaviors, or sexually deviant behaviors.
There's absolutely nothing to suggest that.
So it's
absolutely nothing to suggest that.
But
it wouldn't have been admissible at trial anyway. They're not allowed to put on witnesses to say that he's a sexually deviant person, therefore he must have done this. But the fact remains that this was a guy going about his life that didn't have any sort of significant criminal history, that wasn't the town weirdo. He wasn't. This is a normal guy that was babysitting his girlfriend's infant for a half an hour, and then again for 15 minutes, and there's never been an allegation that he acted, strangely around children. This could have been you or me or your next door neighbor or your brother or your sister, anybody that has ever bathed a child, that's gotten a little clumsy, knows that they could end up on death row, and that's what is so alarming about this case.
But Jennifer, can a defense counsel not? Okay, now Jeff Havard used to babysit for his boss's 2 children, ages 2 and 4. Could they not have called the boss up and said, "Hey, he was a great babysitter for our children"? Is that not a character witness? What's wrong with that?
Well, whenever you're trying a criminal case, it's a judgment call, and you don't necessarily want to call a witness to testify as to the defendant's good character, because then you put his character into evidence, and then what you do is you open the door to allow the prosecutor to bring in, anybody in the world that they want to say he looked at me weird, or I saw him one time, 5 years ago, looking at my child really strangely, or something like that. But the point is that there was nothing that would indicate that they had any witnesses that would be able to do that. More importantly, I think, for as far as character witnesses go, would have been people that the defense should have called during the sentencing. I mean, the sentencing hearing was just as abysmal as the trial, in that, you know, you had Sermos, who was his defense attorney, basically, you know, arguing things to the jury that, you know, that were not even what they call aggravating factors. The jury has to reach certain decisions regarding whether or not a number of factors exist in order to be able to sentence him to death. And Sermos was telling the jury that certain things were aggravating factors when they weren't. I think they put two witnesses up there, Jeff's mother and Jeff's grandmother, with absolutely no preparation whatsoever. Didn't even tell the grandmother or the mother what type of hearing a sentencing hearing is and what types of information they should offer. So there they are sitting there. They have somebody that they very much love and care for, that they're very concerned about, in a position to help him, and they have no guidance as to what kind of information would be helpful at that stage of the game. And, I mean, to say that Jeffrey did not get heard in this case would be the understatement of the year.
Understandable. Let me take a turn here real quick. Justice Diaz, you had mentioned that you had experience on the Mississippi Court of Appeals.
Correct.
Now, common logic to the layperson would dictate that, you know, the first thing brought up on appeal would be ineffective assistance of counsel, as his counsel not only did they refused to cross-examine. It sounded like they were just like mannequins sitting in a chair doing nothing. But not only did they bring only one witness of their own, but they really didn't cross-examine anybody with any substance. They didn't even follow the judge's instructions to consult with Dr. Hain, which could have made a big difference in regards to the medical examination, the autopsy. So can you walk us through how that process worked with Mr. Havard in regards to the Mississippi Court of Appeals?
Well, without getting specific to this case, what happens when ineffective assistance of counsel is raised on appeal, generally, the court is sort of in an awkward position. What the prosecutors will say in response is that it's all coming down to trial strategy, that the defense attorneys didn't ask particular questions because they chose not to ask particular questions. They didn't call
to preserve
witnesses
their appellate
because,
rights.
Yeah, exactly. So raising ineffective assistance of counsel on a direct appeal is not good strategy many times, because it confuses a lot of the issues that should be raised. Ineffective assistance of counsel is more properly raised on post-conviction relief, which is the second layer of appeals. The first layer of appeals is generally reserved for trial errors that actually occurred in the trial, and not questions of attorney efficiency or ineffectiveness at that point. It's really confusing to a lot of lay folks, but the court reasons many times that a lot of the decisions made at the trial level were done for strategic purposes when they're raised initially.
In other words, there has to be absolutely no conceivable reason strategically that a lawyer could have decided to do a certain thing at the trial. For example, why didn't they put any of these witnesses on? Well, there had to be no possible reason that they were afraid that they were going to testify about, I don't know, something irrelevant, or there has to be no possible reason that in hindsight you can go back and say, well, maybe this was what they were thinking. And they will always rule on the side of the attorney per the law. And the only way to defeat it is to say there's literally nothing that could have benefited the defendant by proceeding this way. And that's almost an impossible, burden to meet.
And on top of that, if I'm not mistaken, these, Mr. Sermos and Mr. Clark were two relatively young lawyers, not really well. Perhaps there were other lawyers who were better equipped to handle a capital murder case.
Well, I know that Sermos had got sworn into to the Mississippi Bar in 1997, and this trial happened in 2002. And for example, in the state of California, you're not even allowed to go anywhere near a death penalty case as a court-appointed attorney unless you've got 10 years of some serious trial experience with murders, serious felonies, and capital cases and that sort of thing. Not to mention that Sermos had also been appointed to be counsel on a different death penalty case that had just been tried in November. Now, this case started in December. So I don't really know how you're able to, from the defense counsel perspective, prepare and take part in two back-to-back death penalty cases like that. It's got to take a toll on you and on your ability to really, zealously advocate on behalf of your client.
Yeah, part of the problem is that Mississippi does not have a statewide funding mechanism for defense attorneys. A lot of times what happens is the local trial court will simply appoint attorneys who are available, and then many a times it's the younger attorneys who are available to do these sort of trials on an appointment basis because there's not a lot of money involved. The more experienced attorneys are having paid clients and doing other work. A lot of times it's young attorneys right out of law school trying to establish a practice who get appointed to these cases, and it sort of highlights, you see the problems that arise when you get inexperienced attorneys that end up handling death penalty cases.
Exactly, and it's not a practice ground, basically. You're dealing with somebody's life.
No, you would think the 1.5 day insurance trial would be a practice round, not a capital murder case.
Well, the bottom line that I want to make sure that that I get across to anybody that might be listening to this case is that aside from the fact that there was ineffective assistance of counsel and this legal problem and that legal problem, the fact right now is that you've got a man sitting on death row who was convicted based on a sexual assault that there was literally no admissible evidence of. The doctors and nurses' testimony shouldn't have come in because they're not because of a technicality, but because they're not trained and qualified to be able to make that kind of an advanced diagnosis. So they should not have heard from the doctors and nurses that it was their opinion that this was a sexual assault. Dr. Hain testified, and his opinion has never changed, that there was no evidence of sexual assault. But the jury really was confused about that, had to have been. It was misleading testimony. So you've got a guy that is sitting on death row, and the only thing left is the shaken baby, which Dr. Hain has now completely disavowed, according to Jerry Mitchell, who is a journalist that writes for the Clarion Ledger, that interviewed Dr. Hain very briefly himself and wrote in an article, I believe this past June, that shaken baby syndrome is now extremely controversial. There have been a number of cases that have been overturned where it was determined that the parent or caretaker had shaken the child to death, and we now know what we didn't know then is that all of these symptoms of head injury and so forth can be perfectly consistent with exactly what Jeffrey described. And Jeff now has two nationally renowned experts, Dr. Michael Baden and Dr. James Lauriston, who've looked at all of the evidence, who's looked at the pictures and the medical reports and the testimony, and they have all unequivocally stated this child was not sexually assaulted. And Dr. Baden has said this child was not shaken to death. And that's what we're looking at right now, and the guy's on death row.
Yeah, actually, Dr. Lauriston out of Alabama, and Dr. Baden's near me here in Detroit is his residence. But his actual quote here, I have it, was, and I'll repeat this. These are Dr. Baden's words. The anus can dilate in a coma or after death and any anal abrasion could be due to innocent causes such as constipation or diarrhea. If the child was deceased prior to arriving at the hospital, the anal dilation seen by doctors at the hospital and in the autopsy could have been natural changes in the body upon death. From my analysis, Chloe was not sexually assaulted, and she died of injuries consistent with an accidental drop. Now, for those who don't know, Dr. Michael Baden is not a rookie. He's perhaps the foremost expert in America.
He did Kennedy's autopsy, so he's good enough for that.
That's another show for another day.
Yeah.
But
he is. Dr. Baden knows what he's talking about. The phlebotomist at the hospital, the person that draws the blood, I would think that Dr. Baden's testimony and his opinion would carry a little bit more weight than, the phlebotomist or the coroner who has a high school education and, well, not this one. I don't want to mislead anybody. The coroner, who's not a medical doctor, and the sheriffs, who have no training in sexual assault. The sheriffs were able to take the witness stand and testify that, in their opinion, the child had been penetrated. I mean, it was just, it was.
Okay, defense counsel, you're on. Okay, defense counsel, you're on right now. Now, if I'm defense counsel, I get up there and I say this. I say, could the 1 centimeter mark have been could that have been exacerbated by the fact that the ER staff had to insert a thermometer to take her temperature? Could it have been consistent with the brain injury, as Dr. Haynes said in the 2010 deposition? Could it have been constipation? Could it have been a bowel movement? Could it have been wiping too hard? I mean, we know Chloe had diaper rash that entire week. Pound these questions away at Dr. Hayne during trial, but it seems like Sermos and Clark just stood mute.
Well, the bottom line is that Dr. Hayne, during his autopsy, saw a 1 centimeter contusion, which is a bruise, near the child's anus. He didn't mention dilation in the autopsy report. That is the only evidence that Dr. Hayne documented and testified to regarding, any type of abnormality with the child's anus. And the bottom line is that textbook is not enough for even a doctor to come to a decision that the child has been assaulted. Never mind beyond a reasonable doubt to a jury in a criminal case. And it could have been a thermometer. It could have been a thermometer. They took her rectal temperature 3 times. The state seems to keep contending that, that a thermometer could not have caused the child's, condition of her anus. No, it couldn't have caused the dilation. But, I mean, when a child is brain dead for at least 20 minutes, as this child indisputably was, the body has natural relaxation. The body becomes limp. And one of those things that naturally occurs in these situations is the anus, like any other muscle, starts to dilate.
Let me digress real quick, though, from what you just said there, defense counsel. You had noted that during the autopsy, Dr. Hayne suggested there was a 1 centimeter contusion. However, he testified that was the size of an inch, but he misspoke when he said that. 1 inch, not 1 centimeter. Now,
and nobody picked up on it. So
nobody picked up on that error. So the testimony remained that the contusion was 1 inch, not 1 centimeter. Now, do you think that played a role in anything?
Well, let me put it this way. If the jury is going back in the jury room and they're deliberating whether or not, this condition of the child's anus meant sexual assault, which, they already believed that, Dr. Haynes said it was consistent with, and then you've got all these doctors and nurses saying it definitely was. It was the worst case I've ever seen and that kind of thing. And the one injury that Dr. Haynes tells them he finds is described as being almost 3 times the size that it was. I mean, there's 2.5 centimeters, I believe, equals an inch. So there's a big difference between an inch and a centimeter. And so I'm sure it played some sort of role. It's just even mentally envisioning it, it's much larger than it actually was. Now, I want to make it clear also that he did misspeak. It's in the autopsy report that it was a centimeter and not an inch. But where was defense counsel when there is
I don't know.
an indisputed fact that now is being testified in something that's so critical, testified that it's 3 times the size that it actually was. I mean, there's no excuse for it. There's absolutely no excuse for it.
It's almost like they just weren't doing their jobs, which is something. Justice Diaz, let me ask you this. This is something I don't know, but I'm sure you're more than well versed on this. What happens when the Havard case got to the? Explain walk us through what the habeas, federal part of this case is.
Well, the status of the case now is that it is in the federal system. This was a state court case. It was a state prosecuted as a crime in the state of Mississippi. It was in the local state trial courts. The appeals went to the Mississippi Supreme Court because this was a death penalty case. All death penalty cases are heard directly by the Supreme Court. After the appeal was denied by the Mississippi Supreme Court, it went back to the Mississippi Supreme Court for post-conviction appeals. Those are that's where the ineffective assistance of counsel and some other related matters would be raised. Is on the post-conviction appeals in the state system. Those appeals have also been denied at the Mississippi Supreme Court level. Now, Mr. Havard is in the federal system, challenging his conviction in the federal courts, and it's before Judge Keith Sterrett in Hattiesburg, Mississippi, in the federal courts there, and that's the status of the case right now.
And the bottom line is he's sort of at the end of it. As far as
yeah.
Go ahead.
I just want people to be aware that we're nearing the end of the line here, and that anybody. I'm just saying this because I know that the program's almost over. That anybody that wants to read anything more about this case can go to freejeffreyhavard.org, I believe it is, or Injustice Anywhere.
It's right on our page. It's right on the.
Okay.
It's right on the Blog Talk Radio page. But the show's not almost over. We can last as long as we want or as short as we want, but we won't belabor it too much. I understand. We all have things to do. But does the Fifth Circuit Court of Appeals play a role in this at all?
Well, they will. They can. Right now it's in the federal trial court. When the trial court makes a ruling on this case, it then at that point could be appealed to the Fifth Circuit and from there to the United States Supreme Court.
Now, Justice Diaz, when you say when the federal trial court makes a decision, are you saying makes a decision on whether there will be an evidentiary hearing? Well,
yeah, there are lots of remedies that the federal district judge could recommend. That would be one, is to send this case back for an evidentiary hearing. I'm not privy to the actual motions that have been filed before the federal judge, so I'm not sure exactly what relief they're asking for, but there's a wide range of relief that a federal judge could implement in this case. But the point to remember is that his state court appeals have been exhausted. This case is nearing its end, as Jen said. The federal appeals are really a last-ditch effort. This case, having gone through the entire state appellate process, even with the atrocious facts, the atrocious lawyering work that was done not only at the trial level but also on appeal, there were problems with the appellate counsel in this case as well. It's nearing its end. The appeals are running out, so it has really gotten to a point where everything is almost exhausted at this point. But a federal judge could, in fact, make things right in this case by ordering an evidentiary hearing, maybe appointing some expert witnesses to testify on behalf of Mr. Havard, as should have been done at the trial level. Any range of options are available at this point.
Right.
Do you know who the federal judge out of Hattiesburg is in this case?
Keith Starrett, Judge Starrett, Starrett.
Gotcha. And if Judge Starrett was to allow an evidentiary hearing, what would take place from there?
Well, I imagine that the lawyers that are representing him now on appeal, and by the way, he does have finally some really decent lawyers on the appellate level now.
Fantastic
before
lawyers.
the federal judges, and they seem to be doing a great job. They have really focused this case, they focused attention on this case as it should have been from the start, and so
Exactly.
yes, the trial judge, I think, now has a lot more before him that other judges reviewing this case have not had because of the excellent work that they're doing now.
And let me just say that his lawyers now were the ones that were able to get the deposition ordered of Dr. Hain in 2010. And it was not until 2010 that we actually really knew what Dr. Hain's true opinion is now and what it was at the time, because there's been some confusion about that ever since the very beginning. And that's all because of his current legal counsel, which, you know, it's finally come upon, finally happened that Jeff has really qualified counsel, and I just, it's unfortunate that it took so long for that to happen, because what the state appears to be doing at this point is simply arguing over and over in their briefs that everything has been you know, procedurally defaulted, or that this is procedurally barred. In other words, they're not addressing the arguments. They're simply saying that's, you know, without saying anything about the merit of that argument, you can't raise that now because you should have raised it before. And the point is, we've got a man sitting on death row here, and we all really should be concerned about whether or not he's guilty or innocent, and not whether or not, you know, a lawyer in the past, you know, it didn't occur to him to file this or that.
Yeah, and I'll tell you what, Justice Diaz and Defense Counsel Fitzgerald, I'm still hung up, you know, aside from the ineffective assistance of counsel, I'm still hung up on the fact on how a prosecutor can elicit expert testimony out of a non-qualified witness. That to me bothers me alone, and I think that's something that his new lawyers will probably weigh in on, you know, in their. If
they are, and I think that what the state is arguing is that, hey, you know what, you should have raised that, you know, 10 years ago, and why are you raising that now? Well, the bottom line is that it's so egregious, I think, to allow these people to testify that even the judge sitting on the case should have all by himself raised it. It's plain error in that a person cannot testify as an expert if they have not been proffered and been qualified. No matter how qualified you are, a judge has to determine that you're qualified. So there's not even really any gray area there. So I'm just hopeful that there's an evidentiary hearing and all this is able to go before Judge Starrett, who seems to be listening very intently to the evidence.
Okay. We're going to wrap this up. I do want to ask Justice Diaz one really important question, but before I do that, I'd like to read District 6 District Attorney Ronnie Harper's closing argument, and I just want to read this and get your thought on. But man, I'd like to get both your thoughts on this. So if you can bear with me for a second, I want our viewers to hear this too. In his closing argument, Mr. Harper said, "Ladies and gentlemen, there has still been a lot of emotion in this case, and I don't think you can disregard that emotion you heard from the witness stand. This baby was shaken to death having been sexually assaulted, and ladies and gentlemen, don't try to understand it. Don't try to figure it out. Don't try to figure out what could have happened. Just know what did happen and render your verdict guilty of capital murder, because that was what this man over there is guilty of doing," and I'm sure he was pointing at him, "is guilty of doing." Now, is there, as a layperson, to me, there's something wrong with that when a prosecuting attorney in his closing argument says, "Oh, don't try to figure out what happened. Just know what I say is the truth." You know, is there something wrong with that?
There's certainly something wrong with that. It's a little even more than that. The prosecutor told them that the judge warned you not to let emotion affect your verdict, but I think that it's impossible for you not to let emotion affect your verdict. And then he went through all of the doctors and nurses and how upset they were. There was literally a stream of misconduct. I would go so far as to say in the closing arguments. It was repeated throughout, and the jury was told things like disregard what the judge says to you. Don't try and figure out what happened. Every single one of our witnesses told you the child was sexually assaulted, which is simply untrue. They even argued in their closing, Dr. Hain confirmed for you the doctors and nurses' worst fears. That is simply not true. That's not what his testimony was, and that's what the jury heard right before going back and deliberating.
Which brings me to this. Okay, number one. Okay, where is the judge? Does the judge not have control of his or her courtroom in this case? And number two, where are Mr. Shermos and Mr. Clark? That is, where is Jeff Havard's defense counsel to say? I understand from my understanding, it's not polite, it's not good etiquette to object during closing arguments. However, when a prosecutor says something like, don't try to figure it out, in other words, don't deliberate, just take my word for it.
It's not polite or good etiquette or good ethics or good etiquette, neither polite nor good etiquette to send a man to his death for something he didn't do based upon your complete mischaracterization of the evidence. So at that point,
why not
your politeness
Your
goes out
Honor?
the window. Exactly.
On what grounds would you object? On what grounds would you object to that statement?
Misstates the evidence, number one. It misstates the law. Depending on which statement you're talking about, there was statements of personal belief on the behalf of the prosecutor, statements outside of the evidence.
So the judge says counsel approach. What would you tell the judge?
I would say, Your Honor, this is complete misconduct. The prosecutor is telling the jury to disregard the court's instructions not to let emotion get in the way. That counsel is misstating the evidence by saying that every single one of our witnesses agreed that the child was sexually assaulted. It's simply not true. Counsel is testifying as a witness. Go ahead.
But what really bothers me as a layperson, I could be a juror for all that matter. Remember, a layperson. What really bothers me, and remember, our Sixth Amendment calls for an impartial jury. What bothers me is don't try to figure out what might have, how it could have happened. Basically, to me, what he's saying is don't deliberate.
Correct. Exactly. They're saying listen to what we're telling you, and that's it. Don't listen to what Jeff had to say. Don't use your sense of reasoning. Don't determine whether or not there could have been some alternative theory which might cast some doubt, enough reasonable doubt to have you come back with a not guilty verdict. Just listen to us because we know what we're talking about because we're big bad prosecutors. Total misconduct. And Judge Diaz may disagree with me, or he may not want to comment on that at all. I have no idea, but I get pretty heated about that kind of thing.
Well, I understand Justice Diaz is ethically obligated not to talk about some things, so I'm trying to tiptoe around, what I can and cannot ask him. But if I can, Justice Diaz, are you able to comment on Mr. Havard's 2006 appeal? Which you were a part of?
No, I really can't discuss the inner workings of the court or why or how we did something in a particular case. The opinion speaks for itself in that regard. I can talk in general terms about appeals, but not specific cases that I've been involved with.
Can you tell me how many justices were there on the court and how many of them were in the dissenting opinion?
I could speak to that if that would be
that's fine.
More appropriate. Sure.
Yeah.
I believe that it was almost a unanimous decision. Justice Diaz dissented, and there may have been one other judge, actually, now that I'm thinking about it, but I believe that Justice Diaz was the lone dissenting justice. But the point is that is that a lot of things were not even raised at this point in the state court appeals because, again, Jeff had ineffective assistance of appellate counsel as well as ineffective assistance of trial counsel. And so we're now at a stage where he's finally got great legal counsel with great legal arguments, and to suggest and to find that they can't make these perfectly legitimate arguments that this guy was denied a fair trial simply because it's taken too long when a man's life hangs in the balance. You know, there's something wrong with the system if that's what we're looking at right now.
And I'd have to agree. So let's wrap it up with this. I understand we've kind of pushed our limit, and I do want to thank you, Jennifer. I do want to thank you, Justice Diaz, for your time. I just want to ask you one quick question. I understand he has good appellate counsel, Justice Diaz. In your opinion, you know, with all your experience, but also in your human opinion too, what do you feel the best shot is right now for Jeffrey Havard, A, perhaps to get off death row for one, and B, to perhaps get this conviction set aside? I mean, is this going to be accomplished through media, politics? Is it going to be accomplished through the courtroom, a combination thereof? Can you give me your opinion on that?
Well, technically, I mean, the only way to change the fate of Jeffrey and this case is in the court system. It's now pending in U.S. District Court in Southern District of Mississippi. And those arguments are all being made before the U.S. District Judge there. You know, but as a practical matter, many of these cases turn on the fact that that publicity is generated about the cases. When people realize what has happened in a case like this, when the citizens of Mississippi realize that potentially innocent person could be executed by the state of Mississippi, it makes people very uncomfortable. In cases like Jeffrey's, where you have evidence that was not presented, evidence of ineffective assistance of counsel, the people of the state of Mississippi are very, very reluctant to execute people when the evidence is not there to do that. And one of the only ways to get the people aware of that is through publicity, such as interviews like this.
Right.
And so, you know, you've got to get the word out and let people know what's happening in their state, in their courts. But as a practical matter, judges are going to decide what happens to this case, and Judge Sterrett is considering the evidence at this point, and hopefully the appellate counsel will be able to get his attention and get a fair and decent review of this case.
And I wanted to say that I have full confidence in Jeff's counsel and in Judge Sterrett that they'll be able, the right outcome will occur. But I want to make sure that anybody that's listening to this knows that you know, if their voice would certainly count, that we need to get as much people to become aware of this as possible. So you know, this is truly a case where the unimaginable, you know, it could happen, that if things, you know, keep to continue along the lines that they've been continuing, which is simply that so far Jeff hasn't been heard, and that's all he's asking for, essentially. It's, you know, had he been heard the first time around, then he wouldn't be in this predicament. And now we're at the end of the line, and there's a man's life hanging in the balance, and people need to be aware. So go to freejeffhavard.org and take a look at all the transcripts are up there, all of the opinions from the doctors, anything you could possibly want to find out about the case is up there. Right to ask any questions, and people there are very willing to help in providing all that information.